I'm John T. Brady, an attorney with Vonachen, Lawless, Trager Slevin in Peoria, Illinois. For over 35 years, I've represented fire protection districts in central Illinois. I want to talk with you today about an important change in how fire protection districts must do business when purchasing goods and services. In another video, we discuss the process that must now be followed by trustees of fire protection districts in order to purchase supplies, materials, or work if the contract involves an expenditure in excess of $20,000. This new requirement comes as a result of changes to Section 11K of the Fire Protection District Act. But in addition to understanding the process, trustees likely want to know whether, after they have opened the bids, the trustees must accept the lowest price bid in all circumstances. The answer to this question is a qualified no. If the fire protection district has properly prepared the bid, the district will be looking for the lowest responsible bid. So, will every bid that the district receives be a responsible bid? Perhaps not. Under the language of the statute, the Board of Trustees is not required to accept a bid that does not meet the district's established specification, terms of delivery, quality, and serviceability requirements. In addition, in interpreting bidding requirements in other sections of Illinois law, courts have indicated that public bodies have some discretion in determining what is the lowest responsible bid. This is an area that likely requires assistance from legal counsel if there is ever a question about whether the board must accept a particular bid. As partial guidance, trustees should know that one court has stated that a public body can choose to take something other than the lowest cost bid if the public body's decision is based on a sound and reasonable basis, without fraud, unfair dealing, or favoritism. Throughout the process, however, it is important that the Board of Trustees accurately document that it has followed the steps required by Section 11K, especially in the event that the board determines that the best interests of the district are served by accepting something other than the lowest cost bid. There are other provisions of Illinois law that have previously had little practical impact on fire protection district boards of trustees. With the adoption of this new law, however, the possible application of these other laws becomes more widespread. Without detailing all of the provisions of these other laws, there are laws that are generally intended to prevent abuses of the bidding process, as where bids get rigged or where an attempt is made to avoid the application of a statute requiring bids by splitting the bid into separate smaller parts, so that each part is for an amount less than $20,000, and the bidding statute would not appear to apply on its face. Trustees must be very careful to avoid such situations, since they may involve violations of criminal laws, and the consequences there can be very drastic. Further information about the bidding statute is contained in another video available on this YouTube channel. This summary is intended only to be an overview of the new law. The full text of the law can be found at 70 ILCS 705-11K. While I hope that this information is helpful to you It should not be considered specific legal advice for your situation. As in all complex legal matters, it is important to discuss this new statute with an attorney who is knowledgeable about fire district law and who can explain how the law applies to your fire protection district. Thanks for watching, and stay safe.